First case to come before us today in the state of Ohio will be Erin Stevens. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of time. The arguments are being recorded. When you present your argument, please introduce yourselves, stay behind the podium, keep your voice up. You should not use the names of children or minors or victims during your argument. You can refer to those folks by their initials or terms that are general, like the child. We have read your briefs. We're ready to proceed when you are, and I guess I would just now ask the appellant, would you like to reserve time for rebuttal?
Your Honor, if I may reserve 5 minutes for rebuttal.
Very well.
Yes.
Then you may proceed when you are ready.
Can I just ask briefly, will I then be notified right around the 10-minute mark?
I will let you know.
Okay, thank you so much. Your Honors, good morning. Up front, I'd like to state my name is Brandon Henderson. I am here on behalf of Mrs. Erin Stevens. I do have a bit of a cold, so if I'm not loud enough or if I'm, just let me know and I'll rephrase. As this honorable court is very aware, you have read the briefs. My client was found guilty after jury trial on 3 counts of sexual battery under 2907-03A9. The same date, the trial court judge sentenced Ms. Stevens to 2 years on each count to run consecutive for an aggregate of a 6-year sentence. With regards to assignments 1 and 2, which I'd like to go through briefly, there's 2 arguments. 1, that there was an abuse of discretion. 2, even if the trial court did abuse their discretion, in including the text messages that we would have liked to use, we didn't need to disclose any impeachment material in discovery, and additionally, we didn't need to disclose writing in discovery to refresh memory, as long as that writing was produced at trial, which it was. The main crux of this is we believed that the state provided text. They provided all the texts. They're the ones that had full access to KM. And we only found out through cross-examination of not only KM, but also the detective, that we did not have the entirety of the text messages. There were hundreds of screenshots, completely in disarray. Even the prosecutors themselves at sidebar stated, yes, we know it took Daniela an entire weekend to put them in order. We do not have the state's resources as a criminal defense firm. We simply asked our client, could you take photos and chronologically put them in order for us? So she did. And that's what occurred. The issues with regards to us not being able to get these involved, we believe these messages would have shown the real emotional and psychological control in the relationship was through KM. He controlled when she could see him, he controlled when he showed up for classes, he controlled when he taught classes, he controlled if he was late, he controlled if he didn't want to show up or if he did. These messages also showed that KM held the real position of authority over her as far as their interactions. These types of informal relationships obviously occur every day in every aspect of society. And the power dynamics in interpersonal relationships are extremely complex because there's personalities involved. Had we been able to impeach and refresh recollection with all the text messages, we could have shown the jury that this was not truthfully looked at as a position of authority or instructor/instructee relationship, or that she had any temporary or occasional disciplinary control over Mr. Metler, and certainly not a position of unconscionable advantage being taken of. An assignment of Erin.
Excuse me, counsel, can I ask you a question?
Yes, ma'am.
She was his employer.
That's correct.
Okay. And she was his instructor from the time he was little, but was she still, I know he instructed as well, but was she still instructing him?
Our argument would have been, through the text messages, we would have been able to make a very clear and convincing argument that they were co-instructors, and in fact that he ran the dojo a little bit more than she did, quite frankly. He even testified to that. I don't know if that answers your question.
Well, I guess the point is, yeah, it's not a matter how it can be interpreted, it's just a matter of what the evidence was. Did anybody testify that she was still instructing him?
I believe there was testimony that she was still instructing. Yes, I do. Yes. With regards to assignment of error number 3, we're going to be challenging the statute as unconstitutional as applied to Mrs. Erin Stevens. The facts that are present in this case, we believe it's unconstitutional solely as applied to her, due to the fact that the 1973 legislative intent made clear that the statute specifically targeted offenders in an authoritarian position who took unconscionable advantage of a victim. Additionally, we would state the state of Ohio has no legitimate interest in criminalizing this behavior. Legal age of consent in Ohio is 16. We understand the A9 section here. However, and we would say the sole issue with regards to assignment of error number 3 is whether she was an instructor at this time and an individual who had temporary or occasional disciplinary control over Mr. And is she an offender who took unconscionable advantage of Mr. In an authoritarian relationship, and presenting clear and convincing evidence of the unconstitutionality of this statute when applied to these specific facts in this case, and rational basis testing to demonstrate the unconstitutional nature of the statute and violation of due process. I would like to exhibit some facts. There was no testimony ever that any advantages, demotions, punishments, or disciplinary actions. Engaged in sexual relations whenever he wanted to, and dismissed her and told her no whenever he wanted to. In fact, when asked by detectives twice in an interview, he was asked in a couple different ways, and the first time he said, detective, she kind of held her position over your head, to which Cam replies, I personally cannot recall a specific time where I felt that. The detective then again tries to get information out of KM, where KM then again says, but again, I never felt that. I never felt that she did that or tried to impose that on me, which I think is very telling with regards to unconscionable advantage. So he flat out testified under oath that she never used her position of authority to coerce or threaten him into this relationship. This was never a situation of, if you don't engage in sex with me, you don't move on to black belt, or you don't go to the next tournament, or anything like that. He only engaged in this consensual relationship with Mrs. Stevens when he wanted to, and he actually took proactive initiative to create alone time with Mrs. Stevens, which he testified to. He's also testified to plans that he made in order to deceive one of his friends at a competition called Worlds in Little Rock, Arkansas, whereby he would pretend that he was getting out of the bed with his friend because it was uncomfortable, go to the floor, pretend like the floor was uncomfortable, and then get in bed with Mrs. Stevens. He also took other proactive initiative to spend alone time with her, where he would text her things along the lines of, hey, if I leave this dojo, everybody else will leave the dojo. Do you want me to do that? And she would say, oh, you would do that for me? And he would say, of course. So essentially saying, if I leave, the rest of the students are going to leave, because he was sort of the leader, and then he would circle back and they would have sex in the dojo. None of this ever came to light until he started dating a new girlfriend, where he stated the more closer I grew to his now wife, I realized I couldn't keep it from her, because what if something did eventually come out, then that, for one, would completely, from a religious standpoint, like just more of, it makes me like a bad witness for God. What the pattern of conduct here was, and even he testified to this, orgasm, feel guilty through faith, stop for a while, go back, have another orgasm, either through oral sex or vaginal sex. This happened in Worlds in Little Rock, Arkansas. This happened at the dojo. This happened at her apartment. He put himself in all of these positions.
Counsel, I have a question.
Yes, ma'am.
And I want to know what I'm going to find in the record here.
Yes, ma'am.
The appellee, the state says in their brief that Stevens admitted to engaging in sexual conduct with KM, whom she knew was a minor while he was under her instruction. Am I going to find that she did admit that? in the record?
I think that you may find in a letter that was written where she said that she was, obviously I had an instructor there, she owned the business. There is no, under the 2907 statute, employer-employee relationship. I don't believe, again, when you look at the actual nature, the real nature, not technical here, but the real nature of this relationship, you will see that this lady, Mrs. Stevens, was proactively taking the initiative to try to create a future with this young man. So I don't, a lot of these informal relationships occur, and I believe that it devolved into much more of a friendship, intimate relationship, which not only, TM, who was one of KM's friends, admitted to, it turned into much more of a friendship / intimate relationship. And additionally, KM also felt that it was much more of an informal relationship. So you may see that, quote, technically, there was still this
And counsel, I do want to let you know you're going to move into your rebuttal time.
pretty close.
Yeah, you are there.
Oh, I'm there, okay. I will sit down. Thank you, Your Honor.
Thank you.
Okay.
And I should say, before the appellate begins, with respect to the mention of the name, we will remove that before the close.
My sincere apologies.
Of course.
May it please the court, Lindsay Poparkey for the state. I would like to draw the attention of this court to some of the, I understand that the court has reviewed the briefs in this matter, but I would like to draw the court's attention to some of the facts in this case from the perspective of the state. The record will show that Erin Stevens was the victim's martial arts instructor from the time he was about 10 years old. She was in charge of the martial arts studio the victim attended. The record clearly shows that the relationship between the victim, who was 16 years old at the time, and Stevens, 28 years old at the time, turned sexual in nature. The sexual activity did end in early 2020, and a law enforcement investigation ultimately arose.
Counsel, I just want to stop you if you don't care. The state doesn't contend that that KM was under the age of consent. He had the legal right to consent, right?
He was at the age of consent.
That's what I'm saying. Okay.
The statute is A9, under which it's a strict liability statute which imposes liability on an instructor who has sexual relations, sexual conduct with a minor.
Well, is it a strict liability because it says unconscionable advantage?
That's in the legislative intent
Okay.
of the statute.
Okay.
It's not an element of the offense.
Okay, let me ask you this then. You're right, I was just looking at that, and it is in the committee notes and so forth. But one of the things that they were trying to prevent, they said, were people that were underage
Yes.
being taken advantage of, under the age of consent, or people that could not legally consent. So he's not in either one of those positions, though, right? I'm not saying, that this isn't, sustainable or not sustainable. I'm just saying he was not in the position that the committee comments were talking about, the reason the statute was passed.
He may not have been in that position, but he is a minor who falls under the rubric of the statute.
And the statute says minor.
Correct.
But the whole point of supposedly the statute was so that people that were still a minor and not of an age of consent, or somebody that was disabled for some reason or somehow unable to consent.
I agree with that position, yes.
Thank you.
But
I just want to clarify.
okay, and I believe that the record will show that, as to Judge Sutton's point, that the record will show that Stevens was interviewed by law enforcement. And at the time of that interview, Stevens admitted to engaging in sexual conduct with the victim, who she admitted was 16 at the time, while she was both his coach and instructor. And as counsel pointed out, Stevens sent a letter to members of her martial arts studio explaining that she was no longer a part of the business because she had been charged with sexual battery. And in the letter, she explained that she had been in a relationship with a student while she was his instructor, and that she was a person of authority over him. And even though we've heard a lot about the conduct between and KM's actions, Stevens does not challenge the sufficiency of the evidence or the manifest weight of the evidence used to secure her convictions on the 3 counts of sexual battery. Rather, she initially challenged certain evidentiary rulings made by the trial court, and there was no abuse of discretion in those rulings. On direct examination of the victim, the state utilized a series of text messages between the victim and Stevens to establish the nature of their communications. The defense then sought to attack the victim's credibility through the use of other text messages it had in its possession. As conceded by Stevens, however, in its brief, those text messages were not provided to the state in discovery. In fact, Stevens provided no reciprocal discovery to the state. The state submits that the trial court properly exercised its discretion when it precluded Stevens from introducing those text messages, which it had not provided to the state in discovery. Criminal Rule 16.
Can I ask you a question? I know that they also argue about impeachment, but in regard to substantive evidence, were those text messages proffered into the record?
I do not believe so. And I think our argument in large part goes to ultimately to prejudice, and this court is not going to be able to review whether there was actual prejudice to Ms. Stevens based on the fact that those text messages were not proffered into the record. The trial court is allowed to, pursuant to Criminal Rule 16 as one of its sanctions for discovery violation, exclude evidence that was not provided in discovery. And in looking to the circumstances of the discovery violation here, Stevens has claimed that it was reasonable for the defense to assume that they did not need to provide discovery of their own because they believe the state already possessed all of the text messages. But this claim is belied by the defense's own cross-examination of the victim, where it immediately pressed the victim on whether he had turned over all of the text messages he exchanged between himself and Stevens. And even though the defense was initially precluded from using, or the defense was also given initial latitude to use the text messages, but in ultimately prohibiting their use altogether, the trial court determined that the choice not to provide the text messages in discovery was one of gamesmanship, and to permit the use of the text messages would violate the spirit of the rules of discovery. And the Ohio Supreme Court has stated that the overall objective of the criminal rules is to eliminate the use of, gamesmanship from criminal trials. In the end, the trial court's decision to preclude the use of the text messages was not an abuse of discretion and did not prevent Stevens from maintaining a defense. And the Supreme Court has said as long as a defendant is able to maintain a defense, excluding evidence is not a violation of the Constitution or discovery rules. Ultimately, there was overwhelming evidence of Stevens' guilt, particularly in light of her admissions to both law enforcement and the membership of the martial arts studio that she engaged in sexual conduct with the 16-year-old victim who was her student. And at sentencing, counsel conceded that Stevens violated the black letter of the law. As to the constitutional argument raised by Stevens, we would ask this court to reject that argument. Because the sexual battery statute, which she was convicted of under A9, bears a rational relationship to the legitimate state interest, it is constitutional as applied to her conduct. While Stevens suggests that because that the relationship between the victim and Ms. Stevens was consensual, this argument has been rejected in another case, comparable statute A7, where in a student-teacher relationship, where the 4th District rejected a claim almost identical to Stevens, where she claimed that the statute was unconstitutional because their relationship was consensual. And in rejecting that argument, the 4th District stated, although the appellant describes the sexual conduct in this case as consensual, it does not erase the fact that the appellant was employed as a teacher, an authority figure who the General Assembly has deemed and should be held to a higher standard due to the control teachers exert in students' lives. This is the sort of behavior the legislature intended to punish, if not thwart.
Let me ask you a question. In that case, when the court was looking at 23CA011977, was that student under the age of consent?
I honestly do not recall, but we would ask this court to compare those statutes and say, and here, Stevens' conduct flows directly from her status as the victim's instructor. We would maintain that she was his instructor throughout the whole period of the sexual conduct. She was in an authoritative position as his instructor. And her argument that the victim pursued the relationship intended and consented to the sexual conduct should be of no consequence. She admitted to engaging in the sexual conduct, and she knew he was a minor, and he was under her instruction.
Counsel, I'm trying to get a grasp of all this, so bear with me.
Mm-hmm.
So if the minor here, if he had been 18, he no longer is a minor, so therefore there would have been, even though he might have been a high school senior or whatever, there would not have been any criminal conduct, right?
Under this statute,
Yes, or any statute as far as that goes. 28-year-olds can have sex with 18-year-olds, and they can have sex with their employees that are, 10 years younger or whatever, right? And there's not a criminal violation. There might be civil consequences, it might be sexual harassment, it might be, whatever, but in regard to criminal conduct.
in regard to criminal conduct, under this statute, that's not the facts of this case.
I know, I'm just trying to figure out, because what is troubling me that I'm trying to grasp,
I understand.
get my head around, is this age of consent versus turning 18. Because the point is, when you turn 18, you're an adult for all purposes under the law. But the legislature has carved out a particular age that says you can consent to sex at that age as well.
Mhm.
Now, you may not be able to consent to enter into a contract, which is crazy, but you can consent to sex. So I'm just trying to figure this all out, how it all fits together, that's all. So I was hoping you might be able to help me.
I don't know that I have a response necessarily to that question.
That's fine.
I would just ask the constitutionality question, argument. I would just state that we believe that the statute bears a rational relationship to an important state interest, which is protecting a person under the instruction of an instructor who is over and asserting her position of trust. This individual was placed under the trust of an instructor from the time he was 10 years old, engaging in sexual conduct with a 28-year-old woman when he was 16 years old, and she has admitted that conduct. She was found guilty by a jury, and there is no challenge to the sufficiency of the evidence or the manifest weight of the evidence. And hearing the opposing counsel's arguments, I would just close at that time and ask that the convictions and sentence be affirmed.
Thank you, Counsel. And the appellant will have 5 minutes for rebuttal.
Yes, Your Honors, thank you. I just want to get this out very quickly. Argument 4, or assignment of error 4, is with regards to the fact that there's judicial bias in this case. When you look at this, he proceeded straight to sentencing. The trial court judge in this situation said flat out there's 2 reasons for a pre-sentence report, and we already know she doesn't have a previous criminal history, and I've heard the facts of the case. He even made sure to throw in there, normally I hear them when a plea is taken. And I think there was a point here where, due to the fact that there was a jury trial, which I understand, but at the same point, there was, he goes on to say, well, one of the reasons I think your strategy was deployed here is because double standards exist. I suspect if a 59-year-old shop teacher and a 16-year-old girl, it would be pretty surprising if that person would try to advance, and I was in love with this person and desired affection and kindness. The judge then goes on to say, even after KM's own mother stands up and asks for leniency because she thinks that Mrs. Stevens is a good person and that she made a mistake. Even after that, the judge goes into, but the trial strategy I saw employed here, which involved probably, in the 19 years I've been here, the most aggressive cross-examination of a child victim. He was, mind you, when he took the stand, he was 20. I'm not sure I ever saw one treated that way. And to be honest with you, that shows a certain lack of remorse as well. At that point, my client, Miss Erin Stevens, literally reached over to me and whispered in my ear, but that was you that was cross-examining him. And she was right. And that judge held that against my client. That is straight judicial bias. He flat out said, I'm not sure I ever saw one treated that way, and to be honest with you, that shows a certain lack of remorse. Then went on to say, we find you not amenable to available to community control sanctions. He talked about State versus Fisher with opposing counsel. She was found guilty of 2 counts of sexual battery as a teacher. She was given 60 days house arrest. My client is now in a position where it goes straight to sentencing, no pre-sentence investigation, given 2 years on 3 counts of sexual battery to run consecutive for an aggregate sentence of 6 years. So I would like to state that with regards to number 4 on judicial bias with regards to sentencing. I'd like to say a little bit more with regards to this unconscionable advantage. KM stayed at this dojo for a year after their relationship ended. KM admitted that one of the reasons their relationship ended was because she started dating another guy. He classified what they did under oath as dating. He several times under oath claimed that he was clearly comfortable telling her no in any situation, whether it be working that day, whether it be coming in that day, whether it be anything, he was perfectly comfortable telling her no. Again, he was over to her apartment 4 times, allegedly after he was uncomfortable. They had sex at least 10 times as far as intercourse, and oral sex 2 to 4 times. This is not a one-time occurrence here where this individual took such authoritarian and unconscionable advantage, control over this individual that that he just folded under her authority.
But the state says they don't have to prove any of that.
I'm sorry?
The state is arguing they don't have to prove any of
The
that.
legislative-
All they have to prove is that he was a minor, under 18, and that she was in a position of authority over him, and that they had sex.
And in another case, State versus Moll, one of the same things occurred with a police officer, and what happened, what they found there, was that because his position of authority was not utilized, therefore it should not apply to those specific facts of his case. That was a situation where they met online. I'm not sure if she knew, the girl knew he was a police officer. She claimed herself to be 18, she was not. They had sexual relations, and the court found because she didn't use his position of authority in that situation. The same thing can be stated here. KM himself testified. He said it in his own detective interviews. I never once felt that she used that position of authority over me. That could directly be applied to State versus Mole, where the House Supreme Court reversed and said, no, we're not, this guy's gonna be found not guilty based upon the circumstances of the case. I would also say legislative
Counsel, I'm
intent.
gonna need you to wrap up.
Legislative intent of the statute is much more important than, the legislative intent is the reason for the statute. The legislative intent is saying, is for a person who exerts their authoritarian position to use unconscionable advantage of an individual. That just did not happen in this case, and all the
Okay,
text
wrap up.
messages that
I'm
were,
gonna need you to wrap up, you're over time.
all the text messages that even more admitted evidence would show that he's the one that had control in this relationship. Thank you.
Thank you both for your presentations.
Thank you.
The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website.
Thank you for listening and taking your time. Thank you.